Sir, my apologies. I'd like to reserve 4 minutes for rebuttal.
4 minutes. All right. You may proceed.
Thank you. At its heart, this case is about proportionality and prejudice. The Tatum factor test, 2 of those 4 factors deal with prejudice. Now, in this case, I know the court is familiar with the briefing, but I'll briefly summarize. The plaintiff, Miss Cherry, suffered a fall inside Del Frisco's restaurant, and while no other person observed the fall itself, immediately after the fall, there's testimony from 5 witnesses, including Miss Cherry herself, her husband, and 3 employees of Del Frisco's who attended to her, who took photographs, high-resolution photographs of the floor while she was still there, while the paramedics were attending to her. And one thing that's consistent is that nobody says there was anything spilled on that floor, okay? So there's no transient slip hazard, and that was one of 2 alternatives for how this potential premises liability claim could move forward if that floor was inherently dangerous because of a general continuing condition, or if there was some transient slip hazard like a spill, or some combination of both. So there was a surveillance camera in Del Frisco's. The acting manager, Ryan Cherabowski, who was actually an executive chef kind of filling in while the general manager was on leave, he reported to Del Frisco's vice president of risk management, said that he was going to preserve this video, said in response to emails on 3 different occasions that they had interactions about this video, and it was actually, I guess, the 3rd email was where Mr. Cherabowski admitted that he had messed up and the video was not preserved. So we stipulated that this non-preservation of the video occurred at a time when Del Frisco's was on notice, that it was relevant to litigation. But the big issue here is the difference between relevancy and prejudice. Okay, just because this video may have captured the fall doesn't mean the plaintiff's unable to present their claims without it. It does not render the condition of the floor, which that's the thing itself here. That's the real question. That's what actually existed on that floor. That is subject to proof from 5 witnesses, including both plaintiffs and 3 employees. Now, there were other people there, like the paramedics, who were not deposed, who have not been made part, or who have not been made part of this case. So when I say 5 witnesses, those are 5 witnesses who've already provided sworn testimony, and they're all consistent with one another. So the proportionality here has to first be based on this assessment. What is the prejudice, okay? And where we have photographs that show there's nothing spilled on the floor, where Jack Henry, the server, says he walked back and forth over the floor and there was nothing on it, where Ashley Williams, Ryan Cherabowski, Jack Henry surveyed that floor right after the fall, there's nothing on the floor, where the plaintiffs say they didn't see anything on the floor. How could the video, its absence, be prejudicial? So it's not. But let's move on. The next factor, and this is another place the trial court reached an illogical conclusion. It found that Del Frisco's intentionally destroyed this evidence. So this ruling would stand for the proposition that when a corporation directs its employee to preserve a video of a slip and fall, and the employee just doesn't do it for whatever reason, then that corporation is automatically liable for the civil death penalty of summary judgment on liability based on that employee's negligent failure to maintain that video. And that's what the evidence shows here. This was a negligent failure to maintain the video. So there's no...
How does it show that?
Well, because there are emails from Julie Price, the corporate risk management vice president of Del Frisco's, that instructs Ryan Cherabowski to give them the video. She's working with the insurance adjuster and says, we need this video. Now, initially.
Wasn't the video actually provided at some point in time to the corporation?
No.
I thought there was at least something I read in the briefs that the corporation could access the video.
Mr. Cherabowski testified that he believed they could access the video. The testimony by declaration of Sabrina Scully contradicts that. There's no proof beyond Mr. Cherabowski's testimony that Del Frisco's was able to access the video. And if they could, why would Julie Price be telling him to send it to her? That's the rhetorical question that would seem to
I
give.
didn't say it made sense. I'm just telling you what I read in the briefs.
I understand, Your Honor, and I apologize. That was a rhetorical question. The fact that she's sending these emails over and over saying, give me the video, if she could get it herself, I don't think she'd be sending those emails. And then what would be Ryan Cherabowski's motive for destroying a video? This guy's an executive chef who is filling in as a manager, and he's told to do something by his superiors way up the corporate chain. He has no financial interest in the outcome of this litigation. He's not a party to it. He has only the interest in, preserving, a good relationship with his employer. And that interest is going to be thwarted by failing to follow this. And he even says in his email and in his testimony that, this is bad for me, basically, the fact that the video is not there. And again, you look at the totality of the circumstances. That's the standard that's emphasized over and over in our case law from Tatum, totality of the circumstances. We have a really, intense attempt to preserve evidence right there where they're taking these pictures, they're documenting what's going on, and preserving that for the future.
So why was it not preserved?
That remains unknown, Your Honor. There's been no dispositive proof of that. The expectation, according to Mr. Cherabowski and according to Sabrina Scully, is that these systems naturally overwrite data at a certain point. So if the preservation request was not put in before that occurred, it was gone. But we just know that between September 18th and November 7th of 2018, the video disappeared. That's all we know for sure. We don't know exactly why. We don't know exactly how. That's the circumstantial evidence would indicate that it was overwritten. Now,
is this some sort of digital recorder?
Yes, and it was there's the description of the physical computer components that were in the restaurant, but it's stored to a particular hard drive. There were certain individuals who could go in and log in, but I don't have the details on that configuration in front of me. But yes, it was a digital surveillance recording. And also it's important to look at comparing the supplemental record, page 112, which is a still from this video surveillance system, with the photographs, which are reflected on page 101 to 107. And you can see the photographs are up close, very, high quality visibility of the floor's condition. This fisheye lens from the surveillance camera simply would not have shown the level of detail of the floor itself shortly after the fall. And while, yes, one could speculate as to any number of hypothetical possibilities for what may have been on that video, all of the evidence in the record is sufficient from these witnesses and the photographs to, even if we did have this burden shifted, to prove that the video's absence is not prejudicial, we've carried that burden. So even if somehow it were found that this is an intentional destruction of evidence, we have carried the burden of showing that there's no actual prejudice here. And so we get back to that proportionality. Whatever prejudice there is that the plaintiffs could show, it's really difficult to imagine how they're unable to present evidence on the transient condition of the floor based on all that other evidence. And then the general continuing condition, there's an expert evaluation the parties have performed. And in the record, we just submitted a page from the plaintiff's expert report to demonstrate the fact this expert evaluation was conducted. The floor itself didn't disappear like the tractor in other cases. And it's worth noting that a recent case from this court that wasn't discussed in the briefing, Caldwell v. Ruby Falls, LLC. This is a case where a plaintiff was walking through the Ruby Falls caverns. They alleged that it was overcrowded and that they're walking along this narrow little dark corridor with a handrail, and suddenly they feel somebody stick out a leg, hit them in the shin, they fall, they're seriously injured. There were video cameras everywhere. The people at Ruby Falls said they reviewed a couple of them, didn't see anything, and allowed the data to be overwritten. And the plaintiffs asked for sanctions. And the trial court denied it, and the Court of Appeals affirmed the trial court and said that the Caldwells assert that because Ruby Falls employees knew that video footage would be deleted if not saved, and yet did not view all of the footage from the cavern that day, Ruby Falls' culpability was grossly negligent and rose to a level requiring sanctions. We disagree. That same logic applies here.
Different situation though, isn't it?
Yes, it's different, but not in material aspects.
Well, I mean, obviously you would enjoy the result here, but the analysis is different because the facts are different in this situation. Here you had a specific request, not only from corporate or a specific direction. We want this video, preserve this video. That's not the case in Ruby Falls.
Right. Del Frisco's did more than Ruby Falls did.
That's true.
And
so you're not looking at the same issue.
well, I would say that the issue is the same, but the totality of the circumstances analysis actually falls more heavily in favor of Del Frisco's than it did Ruby Falls.
Well, nobody ever said we're going to preserve the video in the Ruby Falls case.
The court found they should have been on notice that something happened.
Should have been on notice is different than corporate saying preserve the video.
Yes, yes it is. And
A recognition that the video should be preserved.
yes, that's correct. And Del Frisco's stipulated the fact this occurred at a time they knew or reasonably should have known litigation.
And if you're going to rely on that case, you need to send in supplemental authority since it was not cited.
Yes, sir.
Thank you. You've used your time.
Good morning.
Morning.
Elizabeth Russell of the Williamson County Bar, appearing on behalf of appellees Lynne Cherry and Brent Cherry. May it please the court. For this Rule 10 interlocutory appeal, we're under an abuse of discretion standard. And that's because the trial court did its job and did its job well. The trial court entered a 20-page memorandum in order, setting forth its findings of fact and conclusions of law, following an evidentiary hearing on the issue of the appellant's spoliation of evidence. The trial court went into great detail regarding witness credibility issues that weighed in favor of sanctioning the appellants. The appellants do not contest that the trial court correctly identified the controlling authority to be Tatham versus Bridgestone Americas Holding, Inc., nor do they contest that Tatham's totality of the circumstances factors was the correct analysis for the trial court to undertake.
How does this compare with Tatham? Tatham was I think a tractor case where all of the evidence was destroyed.
Yes, Your Honor.
How does that compare with this, where you have 5 witnesses and photographs of the site taken immediately after the accident occurred?
Well, regarding the photographs, what the trial court found is that the photographs showed that there were paramedics and multiple jump bags, stacks of towels, and the appellee, Lynne Cherry, who was injured lying on the floor. It was impossible to tell from those photographs what the floor looked like prior to Miss Cherry's fall. It was also impossible to tell from those photographs whether or not there was a transient issue with the floor or whether there was an ongoing issue with the floor. In terms of the witness statements, what the appellees would argue is that certainly you can take any statement or any sentence that a witness testifies to in a deposition, isolate it, and look at it in a vacuum, and presume that it infers whatever you would like for it to infer. We would argue that the appellants have done just that. They have taken isolated statements from certain depositions and pieced them together to equal what they think is supportive of their position. Importantly, there were only certain sections of each deposition that the appellants included with their memorandums and briefs that were submitted to the trial court. And the trial court said that it would take all of the documents and all of the depositions and all of the information that were submitted along with the briefs under consideration, because the appellants did not call any witnesses to testify at the evidentiary hearing. We didn't hear from anyone who had any knowledge about the recording devices that were used, or about the camera system, or about the delegation of authority, either within the restaurant or within the corporate structure itself.
Did y'all depose any of those people?
No, Your Honor.
So you have no knowledge of what actually occurred either?
We do have knowledge. Mr. Cherabowski's deposition was taken, and he was also called to testify at the hearing on the sanctions, at the sanctions hearing. Mr. Cherabowski was the executive chef, and he was also the acting general manager at the time. He testified extensively, and the appellants produced quite a lot of information during the discovery process regarding their training of both the personnel, the servers, the food runners, the hostesses, as well as the back of the house employees, the kitchen staff, the chefs, and the managers within the restaurant, what their duties were, what their obligations were, but importantly, what they were supposed to do in terms of keeping the floors clean. And they specifically point out that slip and falls in a restaurant is one of the biggest exposures that are posed to a restaurant. They went into great depth in their training materials as to how everyone in that restaurant can help to avoid that exposure to liability for Del Frisco's. Mr. Cherabowski testified extensively to those policies and procedures. He also testified extensively that he ignored them, that he routinely removed the mats from the kitchen, the mats that were intended to keep the grease from the kitchen from being tracked back and forth into the restaurant. He testified to other things, that he removed the knobs from the ovens. He testified that he fired the cleaning crew. He testified at various times that he knew exactly who cleaned the floors that morning, or that he suspected who cleaned the floors, despite the fact that there was no one designated on the company's roster to actually clean the floors. And Mr. Cherabowski's testimony is that the cleaning products they use were intended to be used at night before business the next day, so that the cleaning product had an opportunity to not only fully dry, but to essentially break up the grease and other items that may have been, for instance, tracked into the dining room because there were no mats in the kitchen.
That sounds like all great proof for the plaintiff, but what does it have to do with whether he intentionally deleted the tape?
Well, and Your Honor, there's no requirement of a finding that the video was intentionally spoliated. But what we would argue is that one of the most important facts in this litigation is that at the time that this case was pending, there were two other premises liability slip and fall cases pending in the same state, in the same county, and in the same judicial jurisdiction. Del Frisco's produced a video in one of those same cases in Lisa De Palma versus Del Frisco's Restaurant and Grille. That video was favorable to Del Frisco's and ultimately resulted in the plaintiff dismissing her lawsuit against them. That video was able to show that the plaintiff was ultimately at fault for likely her own fall, and as a result, there was a favorable outcome for Del Frisco's. This was the same restaurant, the same video recording evidence, or same video recording system, the same corporate governance structure, and the same time period as Ms. Cherry's slip and fall. While obviously we can't say for certain that there was any, Mr. Cherabowski certainly didn't testify that he intentionally destroyed anything. But what the trial court found is that there was strong circumstantial evidence that supported that Del Frisco's culpability was high in the destruction of this video.
Was he the same general manager? Was it the same general manager in both cases?
It was the same executive chef, and I believe, I don't want to misspeak. Mr. Cherabowski was filling in for a several-month period when the acting general manager was out on leave. And I can't recall precisely. I'm happy to file supplemental briefing on that issue as to whether or not Mr. Cherabowski was the same acting general manager at the time. Mr. Cherabowski's testimony revealed that he had quite a lot of obligations and responsibilities in that restaurant, whether he had on both hats as the executive chef and acting general manager, or if he just had the executive chef hat on.
Let me pose a question to you. Opposing counsel has said that there were photographs taken, there was discovery taken, and there's no allegation that there was anything on the floor. Do you agree with that characterization?
No, Your Honor, I don't.
Okay.
What Ms. Cherry testified to is that as she was walking to the restroom, her eyes were up. She was walking to the restroom. She didn't necessarily notice anything that was on the floor, but she felt it. She felt her foot slip on something. What the server, Jack Henry, actually testified to, he doesn't really recall what he saw. His testimony, in fact, reveals that he said, "I feel like I remember seeing the floor and there was nothing there." The other witness, Mr. Cherabowski, did not see the fall. He was not present in the dining room at the time. Ms. Cherry's husband, Mr. Cherry, wasn't watching her as she walked to the restroom. So he testified that he didn't see anything, but it was because he wasn't watching. He couldn't tell. Finally, Ashley Williams, the front of the house manager at the time, was in a back office. She did not witness the floor at the time nor the fall, but when she was notified by staff members that an accident had occurred, she went out into the dining room immediately and undertook direction from Mr. Cherabowski about how to handle the accident.
But photographs were taken.
Photographs were taken when the paramedics were there, and as the trial court noted in its findings of fact, that there was a lot of equipment, there were jump bags, there were stacks of towels, and Miss Cherry was on the floor with several paramedics at the time. So that's what the photos depict, is the scene. I don't know that it necessarily depicts or could depict what if there was a transient slip hazard that she fell on. What it certainly could not depict was whether there was an ongoing condition of the floor that contributed to the fall. And we believe that it was likely probably a little of column A and a little of column B. There was probably something transient on the floor, but we also believe that Del Frisco's intentionally disregarded its duties and caretaking for the floor that its patrons are going to be walking on when they came in to dine in their restaurant.
Was there any proof that the camera system would have picked up any transient liquid on the floor at the time of the fall?
Yes, Your Honor. There were multiple cameras throughout the restaurant, and there was one camera in particular that was directly above where the fall occurred. The appellants want to point to just that one slice of time and what the camera would not have seen or would not have depicted. But what's important is we're not just talking about ice or water or a piece of food product on the floor. We're talking about how this restaurant took care of their facilities in order to be able to welcome patrons in to dine in a safe manner there. The video footage would have also shown in the 12 hours before whether it was actually even cleaned. Interesting, there was none of the video footage preserved.
Is that a point of contention here?
Pardon?
About the cleaning of the restaurant?
Yes, Your Honor. Mr. Cherabowski testified that he not only fired the cleaning crew that had been hired to clean the floors, but that he removed the mats from from the kitchen, which contributed to the floor's condition. And as we understand it, no one can testify that someone actually mopped the floors that morning. The fact that they would have been mopped that morning was also problematic because the cleaning enzymes require that they be not mopped the night before in order for them to fully degrease and take care of anything that's been on the floor from the prior shift. So yes, that was at issue as well.
And nobody could testify as to the cleaning schedule or what actually transpired that day.
Correct. There was a piece of evidence offered in at the evidentiary hearing. I believe it was called hot schedules. It's the system that the restaurant uses to schedule their employees for both the back of the house and the front of the house. Multiple employees testified that it was always the dishwasher who was assigned. It wasn't designated in hot schedules that he was supposed to clean the floors, but that it was generally known throughout the restaurant that the dishwasher, that fell within his responsibilities at work. That day, there was no dishwasher even assigned in the scheduling. So we can't even use that analysis to be able to infer whether or not those floors were actually cleaned that day. And we know that the cleaning crew had been fired. Any other questions I can answer? What we're asking for you today to do is to find that the trial court did not abuse its discretion, that it did its job well and made extensive findings of fact regarding not only the proof that was entered at the hearing, but on the witness credibility issues, which were not in the appellant's favor. The appellants can point to no facts specifically that the trial court did not take into consideration. Finally, we've asked that this court find that this appeal is frivolous and that this matter be remanded to the trial court, that the order be upheld, and that it be remanded to the trial court for a determination of damages associated with the appeal. I think that's it. Thank you.
So, Your Honors, I'd like to begin by pointing out that I too heard a lot of descriptions concerning evidence that would be favorable to the plaintiff's case that has nothing to do with this video. The scheduling, or if there is a lack of evidence about whether someone cleaned that floor that day, and that is a part of the plaintiff's proof, and there's no evidence produced by the defendants, then that too could be the subject of a missing evidence instruction, not even a sanction for spoliation of evidence, but just a missing evidence instruction where evidence is in the control of a party and they don't produce it. So there are a lot of ways that I heard the plaintiff could prove claims that don't involve this video. Also, concerning the other cases and the other surveillance video, I do not know how much of that is a part of this case's actual record. I know some of that is, but again,
I'm not sure what you mean.
Concerning who was the general manager, Ryan Cherabowski or another person, whenever this other video was produced in a second premises liability case.
Was that evidence in this case?
That was just argued by opposing counsel. I don't know.
I understand.
Yeah.
What I'm asking you was that evidence that was presented in this case regarding this missing video.
There was some evidence on that subject. I don't recall whether or not the general
Were you
manager.
trial counsel?
Yes, I know for a fact what it was. I just don't know if it was in evidence in this case. And to my recollection,
Again, I don't know what you mean, what you just said. If you're trial counsel, you don't know what evidence was introduced in this case?
Your Honor, I do know what evidence was introduced in the case.
Well,
I just don't recall whether that specific fact of whether it was Ryan Cherabowski or a different manager. I don't recall if that specific fact. I'd have to review the record. It's a pretty
This seems pretty significant
900 pages.
that there was another instance, and so you don't recall that?
Your Honor, I do recall the incident, and that is, in fact, the video still that's submitted in the technical record is referenced as part of that case, I believe. So the video still shows generally what is captured by the surveillance cameras. And that's still in response to Judge Armstrong's question about whether it would have captured a transient hazard. The court can look at that and see, here's what's visible on those cameras. Now, again,
Would the cameras have recorded the cleaning for that day
presumably, yes.
if the video had been retained?
Yes.
Okay, so we would have known which employee cleaned at what time, those kind of issues.
Presumably, yes.
Okay.
And again, we can also look at these photographs that were taken. Counsel says they're showing paramedics. Yes, some of them are, but let's talk about the sworn deposition testimony of Ashley Williams, who took those photographs, who said, I took these photographs. There was nothing on the floor. She took photographs of all around the area where the plaintiff fell. Those photographs combined with her testimony, and then everyone else's testimony is consistent with the fact no one saw anything on the floor.
Did the plaintiff not testify that she felt something on the floor?
She felt her foot slip out from under her.
That's different than what opposing counsel just stated, isn't it?
The verbatim quote for the plaintiff's testimony is contained in the brief. She testified that as she was walking to the restroom, her left foot hit a slick spot and went out from under her, with her left kneecap breaking in the middle of the fall. And that's on the supplemental technical record, page 72.
Okay.
That's,
Yeah, let me ask you, you said the trial court went too far with the
Yes.
sanctions in this case.
right.
What do you propose would have been an appropriate sanction for failure to not preserve the recording?
Yes, a permissive negative inference sanction. And that would be consistent with the case law that we've cited. And I even proposed such an adverse inference instruction. And it would be in adherence to Tatum's fourth requirement, that the sanction imposed be the least necessary to remedy prejudice. And here we would have a sanction where the jury may draw a negative inference that what was on the video would have been generally bad. And they can evaluate Del Frisco's explanation for why it's not produced and make that factual finding. Here we have the sanction that liability is 100%.
I think you've answered Judge Armstrong's question.
Thank you.
Thank you. Thank you, counsel. We will take this matter under advisement. We appreciate your brief.